are in listen-only mode.
Okay, so welcome everyone. We're going to get started in just a minute. If you are having any trouble hearing us or seeing, please go ahead and type us a question or a chat in the question box or chat box so we know if anyone's having any difficulties hearing or seeing the presentation, but we'll get started in just a minute. Yeah. Okay, so it is 12 o'clock. I want to welcome everyone to our webinar, Third Thursday training on service of process, the basics and the challenges. My name is Margaret Henn. I'm the Director of Program Management here at MBLS, and I just want to thank you all who are on the webinar for joining us and for supporting pro bono and supporting MBLS. So for many of our volunteers, chances are at some point you have had a situation where you had to serve a party in a case and maybe had some challenges doing so. Some of the barriers that we typically see come up for our clients can be things like trying to serve an incarcerated individual, a party evading service, alternative service issues. So we are very lucky to have Thomas Mulinazzi from Mulinazzi Law Group here with us today to tell us a little bit about both the basics of service and also how to navigate some of these particularly challenging situations. So before we get started, I just want to remind you all that there is a PowerPoint that we're going to be going through. This is available to our audience attendees through the handout section of your GoToWebinar. You should see something that says handouts, and the PowerPoint has been uploaded for you. So you will have access to that, and we'll be running through it on the screen here as well. And if at any point in time you have questions, we would love to take your questions and address them. I will be collecting them, and then at the end of the presentation, I'll let Thomas know what those questions may be. So please do feel free to type in questions as we go along, and we'll be happy to address them at the end. So without further ado, I'll introduce Thomas Mulinazzi. His practice focuses on family and domestic law. He is an experienced litigator, and he has been a very valued pro bono attorney through MBLS for a number of years and has taken over 140 family law cases with us, and many of them quite complicated, contested matters. So he has a lot of experience working in this area and working with pro bono clients, and we're very lucky to have him here today doing this webinar for us. So with that, I think I will go ahead and turn the presentation over to Thomas.
Thank you, Margaret. Thank you all for participating, and thank you for your service. I'm sure that you have either done a few or dozens of these cases for MBLS, or you're about to, so thank you. And I don't think I have all the answers, but I'm going to give you a lot of information, and if you have some information to share with the group, then there's a couple different ways to do that, and Margaret has that under control, but I think there's a chat feature. Is that right, Margaret?
Yes, yep. Mm-hmm.
Okay, so if you have an idea that will help the good of the order, type up, speak up, whatever it is. And maybe I'm wrong, that's fine too. I can live with that. So feel free to chime in. So that's the first slide. That's me. I've really thought that Kids to Panic should get credit for on the front page. This.
I have to click on it. You have to click on the PowerPoint.
Hold on, we're having minimal.
Oh, there we go.
All right, so that's us, and that's Kim in the front there with the bright blue shirt on. I point that out because she did most of this PowerPoint, and I appreciate it. So, is there a way that
It should advance. Now we think you're good to go. Yep.
All right. So, start off with the easy stuff. How to serve a defendant. You may know some of this, all of this, and that's great. But also, part of what I'm going to talk about is alternate service. But let me start with this idea, and you may or may not agree. If you serve the defendant, let's just call this person the defendant, you won't need to get to alternate service. So that's probably makes sense to you. And if you use various ways to attempt to serve the defendant, you will also be successful in your motion for alternate service, which we'll get to very soon. Okay.
I'm sorry.
All right, so this is the rule. I moved these around a little bit. I inserted the highlighted portion, but this is the essence of the rule. And I tell people there's three main ways to serve someone. Hand delivery, which is simply handing the paperwork to the defendant, all of the paperwork. I'll say it now, and then I'll say it again. The biggest thing that usually is not served is the writ of summons. On the other hand, sometimes it's the only thing that is served. But as you all know, everything that you file, even if it's the domestic case information sheet, a copy of everything must be served along with the writ. If you can hand it to someone else, that can only be an adult resident that lives with the defendant, and only if you're serving it at the home of the defendant. So people have roommates, family members, and that is something that sometimes that's the easiest way to do it. And then there's certified mail, but it must be restricted delivery. So there's the rule, and I'll go into, I don't want to say into detail, but I'll cover each one. I pulled the next two slides from materials that Baltimore City, Circuit Court for Baltimore City gives out. I thought this was interesting because this is what people see when they don't have an attorney. I also thought it was interesting because if you look at the first sentence, what is not there is a writ of summons. So this is actually this is wrong advice. But this is what the folks see, and we need to make sure that we follow it too. Moving on to the next one, so you could either have it private process server deliver it or certified mail restricted delivery. These are the boring slides. We'll push through this, but I'll explain each in a little more detail. The next slide is something that came off of the court's website, which explains private process much better. This is a slide you have. It says in more detail what I've already said, and we're going to cover it. So let's start with mail, certified mail. It's the cheapest, right? So if you get lucky, you could just mail it to the other side. Maybe they'll sign for it. That's fantastic. That's about $7, depending where you are. There might be an upcharge if you're in a shared office space. They might charge you a little more. Just mail it to him or her. But you notice the highlighted portion. This must be restricted delivery. So when people will talk about certified mail, and that's fine, but it's not correct. It's certified mail restricted delivery. Because as you see right above the highlighted portion, there is something called certified mail. That does not comply with the rule. That will be rejected by the court, and that might be your only chance to get this person without being really creative, and you just blew it. So you have to check the box. And if you have a situation like we do where we're in a larger office space and we can ask a third party to do the mailings for us, you have to be really clear you want restricted delivery. Otherwise, you're just wasting your time. So if it comes back to you, the green card comes back signed, you probably can't read the signature, but if the box is checked, you're probably going to be okay. Of course, you really should get your client to be able to authenticate the signature, but that's another matter. So that's the cheapest, that's the easiest. Or you could do sheriff service. So sheriff service, it's $40. It's just statewide, that's the fee. The sheriff's, my office doesn't do that. very often, if at all. And my thinking is, and you can disagree, is that it's a little invasive. It's this is a sheriff's deputy from Howard County who we like, and she's, as you can see, she's very friendly. And yes, we did post that on Facebook. But you know, they're not all like that. And if you're not an attorney, it's kind of scary to see someone with a gun show up at your door, your work, or whatever. That might be the wrong way, the wrong foot to get off on, especially in a domestic case. But it still absolutely complies with the rule. They will make 3 attempts on their schedule as they group these servicings together so that they don't waste fuel and time. And they may get the person, they may not. They're not as invested in serving your defendant as you may be. So, but it could work. And if there's security reasons, then you should probably use a sheriff's deputy. But what if we just do someone other than sheriff? Well, it can be anyone, but not the party, or depending if it's a multi-party case, it can't be a party. They have to be over 18, and they can be 18. It's an adult. It might not seem like it sometimes, but that counts. It could be your friend's older kid, or a cousin you have is 19. It doesn't matter. They have to be competent to testify. So I say anyone can serve, but not you. They have to be an adult and not insane, which is not exactly accurate. They just have to be competent to testify because they'll have to fill out a form. So sometimes we will have, we call them friends of the firm, serve people because it doesn't require a great deal of expertise. My apologies to the process servers, but I bet you they would admit that. You just have to have a human being pass the paperwork to the target, the defendant, and they can say whatever they want. We really encourage our process servers not to be dramatic. It's not TV. We usually put it in an envelope, and it may say court papers, or it may just have the target, the defendant's name, and we'll say, these are court papers for you. These are important papers for you. I like to tell our people to use the word court. Whatever is easiest, whatever is most efficient, and since we're talking about, you can take this to your full practice, of course, but if you're doing judicare or pro bono cases, you want to be most efficient. So maybe you get away with the certified mail, but now you're eating almost $10. Okay. I don't think you want to do sheriff's service. So you could possibly get a third party to just simply hand deliver this. Those people usually say to me, what if they don't take it? Well, if they don't take it, then you just drop it at their feet. You put it on the desktop. You put it on the car hood. You put it within their wingspan. And most importantly, make sure it's safe for people to do. 2 days ago, I had a friend. She does a lot of these things, but when she went down to an apartment in Washington, D.C., she literally ran away because she thought she was hearing gunshots. And that can happen anywhere, so no offense to Washington, D.C., but I'm sure that they probably were gunshots, so I feel horrible, and I'm going to have to pay her a lot more next time. So there's that. You don't have, if it's, this is just for your amusement. So anybody can do it. You want to pay someone? Okay. You want to, because it's a rough area or nighttime or a parking lot, anyone can do it. And we have in the past used, in the past we feel we've gotten creative. So here's a slide with 3 different examples, all of which we've used. Everyone answers the door, almost everyone answers the door for the UPS person, but you're probably gonna, whoever's uniform it belongs to will probably get in a lot of trouble, and it's a good job. You don't want them to lose the job. Everyone answers the door for the pizza person, especially now that it's Domino's is doing this TV marketing ad where they just show up with the pizza you didn't order to make up for some past transgression. So everyone thinks they're getting a free pizza now. And I used to have a client who worked for Papa John's, and we had to get creative. So we did a little service exchange where he would serve people. And I had the good fortune of being on the phone one time while the service was happening. So I was speaking with the defendant, which in that situation I kind of had to do. And I heard the door, and her daughter went to get the door, and she said, "Mom, the pizza guy's here." She had some colorful language about how she didn't order pizza, and she went, I could hear her go to get it, and when she opened up the empty box, I could hear what she said, which Susan Francis says I'm not allowed to repeat. And then she came to the phone and said, "Is this even legal?" And I said, "Well, I mean, yes, to answer your question, but it's just a matter of getting the papers to you. So now you have them. Thank you." And that's that. But the Facebook post to the left is a true story. And that was also Kim Stepanek, who thought the best way to serve the bank would be to shove the subpoena up the vacuum tube. And so I really did get a call from the bank's lawyer the next day, and I played dumb about it, but he agreed that by the time he got done explaining everything to me about what happened, that he had probably just acknowledged that he received service. And that's that. Check the box and move on. So you do what you have to do, and people may try to evade a little bit, but when I say you do what you have to do, you don't have to do this yourself, or you could if you're up for it. It can be very fun, or not. This morning, another law office thought it was a good idea to have our law office personally served with a process server for some paperwork, which is fine on its face, but in our county, it's a smaller county, and well, first of all, you can serve via MDEC now, but it's just overboard. So we had a little fun with the process server and didn't let her get past the receptionist. But then I went out into the parking lot and knocked on her window while she sat in the car waiting for us, and served myself, and then took a picture and sent it to the other side. It shouldn't be a big deal, but you do have to get creative sometimes when, depending on the people you're dealing with on the other side, they, and I'll try to say this politically correct or gently, in certain populations, they are less comfortable with police and lawyers and judges, etc. And as such, they are not happy about being served with papers. Often they think it means more than it does. It's, to us, from my perspective, it's just delivery. And you need to have the papers, and from the court's perspective, the court needs to know that the other side got the papers, or at least that you're trying. And then there's this guy who is hopefully not watching right now, but he's actually a member of the bar, so he doesn't have enough to do, I guess. So has evaded service a lot and often, and keeps making the case more complicated, so that I have to continually serve him with the original process. We were able to serve him once at the courthouse when he was representing someone else, but we had to get a process server a couple times. Anyway, so you should work with your client to get as much information about the defendant as possible to help the service. So where does he work? Does she always go to the same bar after work? Does he come home at a certain time? Does she work out at the gym every Tuesday at 6? Is there a kickboxing class? If it's a domestic case, your last resort is when he or she just is seeing the children. That's not good for obvious reasons. You want to keep the children out of it. Now, on the other hand, once the visit is over, children are gone, and there he is. But this gentleman, we have finally tracked him down coming out of the subway. So, and it is always best if your process server will send you photos. I say all this because there may come a time, depending on the type of party on the other side, where you have to prove to the judge that the person was served. which is interesting when the defendant calls the court, writes a letter to the court, or shows up at court and says, I wasn't served, because the judge is wondering, well, how did you know to be here in the first place then? So, but it can also help your case for a number of reasons, whether it's a pro bono adjudicator or a paying client outside of envelopes. I'm going to take a breath, and if anything, any chat pops up where we need questions.
Okay, let me take a look. So if anyone wants to have some questions, we're going to take a brief pause here. If anyone has any questions at this point, one of the questions that I received was just about the materials, and someone's having trouble downloading them. So I'll just say real quick that we can email them out to the attendees after the presentation. Does anyone in the room have any questions at this point? We're good to continue.
I could tell, let's get off of this guy's face. A couple other interesting anecdotes.
I think I might have gone one.
I must have. Oh, I see. Okay. Yeah, okay. I mentioned before that what happens if the defendant doesn't take the papers? Well, that happens a lot. You don't want to be rude, but I've had a couple of process servers, they'll usually call me up and tell me if anything interesting happened. In one situation, a process server, a gentleman, and I explained who this guy was. He's not violent. He's a professional, but he's kind of a jerk, so expect that. Okay, well, that's what she got. She got a jerky response, and he actually tossed the papers back at her as she was walking away. And she decided she didn't like that, and she picked them back up and tossed them back his way, which was kind of silly. But she knows that once the papers are in his wingspan at his feet, he's been served, and sometimes it's best to take a photo of that. Similarly, one of our process servers was working with the mom to serve the dad after supervised visitation. We had a photo of the dad, and the mom is on the phone telling us that who this guy is. Yes, there he is. There's his pickup. So we took a picture of the pickup, and when the process server approached him, he denied that he is who he is, and she said, I know who you are, and she just tossed the papers into the cab of his pickup. So that counts.
So it looks like we do have a question. And the question is it enough that the defendant uses his mother's address as the mailing address, even though he might not really live there? If the mother accepts service, does that count?
Well, like everything, it depends in the sense that, so is it enough that the defendant uses his mother's address? I'd be curious what that means. If that's his address of record, again, what does that mean? Utility bills, or if there has been past court filings with that address, or if this is a active case and you have to serve the person with original service for contempt. That's the easiest one. He's come to court. He's told the court his address is 123 Bleecker Street. Okay, well, that's it then. If he's using his mom's address, he's using it. I would, in that situation,
I guess maybe they're saying it's an address he pre-provided to the attorney. I'm not sure if they mean his attorney or the opposing counsel.
So that's very helpful. Thank you for adding that.
Yeah.
I would include, especially since he's sending it to you as the opposing counsel, I would include whatever correspondence he sent to you stating, hey, this is my address, along as an exhibit with your affidavit of service, which we're going to get to next. Remember, you just look at it from the judge's eyes, and some of you have done clerkships. I did too, and behind the door of the judge's chambers, they just want to make sure, is this reasonable that this person should get this information? Well, I think so. But he's telling you, hey, I live here, and okay, so that's why we served you there. And this lady who is your mother, clearly over 18, she lives there too. And then I would follow up with an email or some other communication means. I don't think you want to text them, but an email saying, and attaching it. Hey, here's the information. We just served your mom at this address. Because now what you have is, as you know, the email to a pro se defendant is not acceptable service, but it's a backup. So you're just trying to cover your butt, really. I think that's okay. All right, filing an affidavit of service. And this is where we are now. So at the end, so this is from the Baltimore City pro se explanation. This is what Baltimore City is telling people at the desk. This is what the affidavit of service looks like. Now you can type up your own, that's fine. But, and we've probably all done this before. I highlighted a couple of things. You do want to fill out pretty much everything. But the big red arrow is next to the writ of summons because, again, we would love to just grab everything we filed and serve the person as soon as possible. But you have to wait for to get the writ of summons. And different courts, you get that at different speeds. Sometimes the same court, there are different lengths of time you have to wait depending on their volume. Some courts let you stay there, sit there, and beg and plead and ask for it and get it the same day. But well, let's be candid, you probably don't want to spend that much time doing that in a pro bono case, being that time is money. So you want to be as efficient as possible. So just wait. Calendar it in your system, wait for the writ of summons, make sure it's there, check that box. Make sure that whatever you filed is in the service packet. And then inside the red box, please explain. And so maybe I'm talking to you personally, but if not, you've got to explain all this to your process servers. Unless you're going to go with the professional process service, which we'll talk about in a second. And even then, you have to be careful. Look at their affidavit before you file it. And then again, sometimes they file it on their own because it could be deficient. You want to nip it in the bud before it's filed with the court. So if I'm looking at an affidavit of service and it's not completed, I'll call up the process server. So you have to add more as long as it's true. Because if I submit this and it's deficient, we're done. I can't resubmit the same thing after adding more. That seems to be patently unethical. So there's that. So I thought, I have a typo there, sorry. The fee for service by Baltimore City Sheriff is not $4, as you probably would expect. It's not. So anyway, there are various costs. The sheriff service is flat, it's $40. Unless, right? Unless you want them to do it again after they tried 3 times. It's also difficult because they might not do it out of counties. And then you have to transfer it over to a different county. There you go. So who else can serve? Anybody over 18, not you, not insane. Private individuals, the costs differ. Sometimes you're in the courthouse preparing for a hearing, but you have a show cause with you that you need to serve, and you don't want to be the one to serve it. If you have an affidavit of service on you, you can get the guy sitting next to you to do it for $5. But normally, you're looking at $50, $80 or so for a private person to do it. If you have a pro bono case or a low bono case and it's an easy service, well, one, you probably don't even need me to tell you how to do it, but then the cost can be lower. But we pay our people between $50 and $80 depending on the circumstances. There are private process serving companies out there. Sometimes they're private investigators, but they don't have to be. So one company that we use a lot, that we got the name of them, I think, through MBLS, is Monumental. And I think they do a reduced rate for MBLS cases. I think it's $30, but it depends on the situation. The one we have on the left-hand side is over $100, but that's because, so their standard fee, 65, then you see the rush of 20, and then there was a whole lot of paperwork that went with the filing, which I can't imagine came from us, but we had to. And in any event, they charged us 20 cents a page, which is, is what it is. So that's not usual. It's usually about $65, but they do offer discounted services for MVLS cases. And then the one on the right is just another company we've used before. They do good work as well, so it's $60. It is also, you probably know this, these businesses are all over the country. So you just go into Google, type in whatever city you want, and they're going to pop up, and give them a call and see what their fees are, and ask them if they will fill out the Maryland court's affidavit of service, because they do fill out their own, and it may or may not be good enough. I'm gonna try to be fancy here and go backwards. Like, will it have all the same information as this one has? Better. Otherwise, you just paid however much money, and you may or may not be able to get a hold of them. And I've had situations where they said, well, I'm happy to fill it out more, but you're going to owe me another $30. Or it's more than frustrating, because in my mind, they messed it up. Anyway, I don't know if I should invite. So now we'll go to this, which kind of gets us into alternate service. Again, you want to do everything you can to find the defendant. So you should also be creative. It's a new world, and there's a lot more resources at your disposal. And to that end, there is a new form that came out June 2019, Motion for Alternate Service and Affidavit. It's CCDR 070. It is one of the slides. So how do you find the defendant? Well, why not look on the judiciary case search, right? We look for everything else there. By the way, it's a fun way to run your neighbors, see what's going on with them. I'm pretty sure everyone on this webinar probably already does that. This is, I love this one. This is from several years back, one of my first MVLS cases. I didn't do this, the client did. So you really have to work with your client. Hey, where is this guy? This Johnny Ace. Who does he run around with? Where did he live last time? Is he with anyone else now? What about his mom? Does he have any brothers? Those kinds of things. And then start to reach out to those people. What this is the client created, let's call it a flyer, because that's what it was. And she printed it out old school, and she taped it to bus stops and liquor stores and other places all around the east side, asking anyone know whereabout of a Mr. Cameron. And it didn't work, but the judge was really impressed with it. And I love the photo. I mean, I did not make that up. So, she's being creative. Now, of course, you're going to Google it, wouldn't you? See what you get. There's also a million other ways to look around social media, right? And it is really easy to find people nowadays. That being said, the populations that we often deal with when we're working with low-income individuals, they rarely have LinkedIn profiles, for example. They don't usually care too much about their internet presence. Maybe with Instagram and Snapchat and whatever, you might find that. But as the teenagers know, there's also people go by aliases. You can look at the white pages. Not my favorite, but that could work. I don't have a slide for this, but what I'm about to say. But one of our attorneys Turns out it's Kim Stepanek again. It's almost like no one else in my office is doing work, but good for you, Kim. She had the idea to subpoena the Washington Suburban Sanitation Commission and ask them for the billing address of the, again, let's call this person the defendant. And they actually gave it, which, I didn't think that was going to work, but, we found the person using that. So if that works, then maybe it would work with BGE or Pepco, maybe. And then it's a cost-benefit analysis if you want to try. Or you just send it out there and then they say, we're not going to give you the information, but at least that attempt makes it onto your affidavit with the court for all the things you've done. Incarcerated defendants it's pretty straightforward. You use this website, bind link. Type it in, boom, up pops this. Sorry, Umed, but you get to be our example. It may or may not be his correct date of birth. Just don't look at that. So go to Vine, type it in, and that'll pop up. If they're in the system. If they're not, then they're not incarcerated right now. Then the question is usually, well, how do you serve them? Quite simple. You just send it care of the warden, and someone will sign for it. Hopefully, or presumably, they don't have a cell phone or email account while they're incarcerated. Maybe they do. You can always send an email. If you get a response, there you go. But this is the way to do it, via Vine. You also need to, if you have reason to believe they're a service member, this website has the information that you need to input, and if they are a service member, it will tell you, it will confirm that, or it will say they are not. You do need their social security number and their date of birth. So that might be hard to get, especially when you're dealing with the populations that we help through MBLS. I don't know if they're going to know the other person's social security number. They might, but regardless, some of the income level, some people don't know their child's father, their child's mother, their husband who they haven't seen in 15 years. They don't remember the social security number. Okay, well then this won't work. But you're gonna have to figure something out with that because you really have to submit this, as we will see. Okay, so the rule requires you, backing up a second, alternate service is only necessary when you're unable to serve the defendant. You probably knew that, but let's just keep it in context. So then what do? Because you can't move forward with the case, you can't file for default. So the only thing you can do, if you've tried like crazy and made significant efforts to locate the defendant, is to ask the court, can I please serve this person through an alternate means? So, which is ironic, well, not ironic, it's interesting because the alternate means 200 years ago would probably be some guy in stockings and with a bell in the middle of the town square and posting it, the service on the courthouse. That's the historical origin of that, and it doesn't do any better. In fact, it's probably worse. But, so some of the things we have done, here's a couple of examples. When I couldn't find someone, I asked my client all about her, and I looked her up on Facebook. And when I found her on Facebook, you can also find her friends if they leave their profile public, which, believe it or not, some people still do. So I was looking for a Miss Mutahi, and I decided I'm going to look at her photos, and I found that this Miss Mugambi was her sister, so I just messaged her in to the right is my message. And I hope I was not very aggressive about it. It simply said, he's asking only for a divorce, no money. Why not just, I'm sure she wants a divorce from this guy. He's probably no gem, so she probably wants to move on also. Then I Facebook Messenger, Kathy Mutahi, and then Ms. Mugambi again, with very, very similar message there. So what I'm trying to do is encourage them, hey, I'll send you an answer form, you check the boxes, you send it in, we're all done. And I just want to normalize service for them. That's what I'm trying to do here, because it's not a big deal. It's just delivery, and then you get your chance to answer and say whatever you want. Similarly, former client of mine was a retired Prince George's County detective. He was the best process server ever for obvious reasons. He had a badge, a gun, and he knew what he was doing. But one of his techniques was simply to contact the defendant and say, hey, buddy, I'm outside of your house right now. I'm a retired police officer. I have court papers for you. Can we just do this the right way? Just, put your pajamas on, come out here, and I'll hand it to you. No big deal. And, if they thought they were going to be wise with them, then it was on. But 9 out of 10 times, they would just come out and take the papers, and they were best buds. So you got to normalize service especially when you're trying to find the defendant, because you might make contact with the defendant, but they're not going to answer. So in this case, I'm pretty sure Ms. Mutahi is getting this message, and if not, her sister is probably calling her, what's the deal with this attorney calling me? So then I talked to my client about it. I said, are you hearing anything? He said, yeah, actually, here's the text exchange going back and forth. Now, at this point, I still don't have an answer from her. But like the question about the address, well, how do I know if it's the correct address? But the defendant gave you the address, and then you can follow up with an email. So this text exchange made it to the affidavit, motion for alternate service. The judge was more than satisfied that Ms. Mutahi is getting the information, and she's choosing to not answer. So this is the new motion for alternate service.
Do you want to wait do you want to hold questions for a minute?
Well, I'm looking at a question that someone sent us, so that's great. So the question, I'll make it in the form of a question. Can an attorney do the service? Yes, but it's a bad idea. So the attorney qualifies because I'm not a party to the case. I am over 18, and for the general consensus is I'm sane enough to testify in trial. Now, you may say, well, attorneys shouldn't be witnesses. That's true. I grant you that. We will often have, if it's easy, a different attorney in the firm do it. And depending on the county and what judge you have for your case, all they want to know is that the person was served. So if one of our attorneys says, yeah, I served them and that's it, I'm not really involved in the case, but that's me, that satisfies the judge. So thank you for that question. It is, I do know a lot of my colleagues will not do this, will not have their staff do it because they don't want to make their staff a witness. I get that, and I respect that. I would say if you're going to do pro bono and low bono cases, you have to be efficient and whatever works. So know your judges, and if it's just a matter of having, you can do the service. Probably shouldn't, but you can. So thank you for that. So the motion for alternate service. I could have started here and worked backwards, but you'll see in paragraph 2 that this is from this summer. You see at the bottom of the slide, it says revised June 2016. there's a lot of references to what you could and should be doing on the internet. But if you can't find this person, you really have to make other efforts. Contact people in their circle of friends and family, get as close as you can. It doesn't matter if they don't call you back. It doesn't matter if they say they know where the defendant is. What matters is that you tried. And I bet, I don't know any of you, but I bet if I called up your mom, your two best friends, and someone in your office building, you will hear about it pretty soon and either file protective order from me harassing you, or you just call me back and what the heck do you want? So, you're trying to do enough of this so the judge sees you've done everything you can. Obviously, the last known address at the bottom. Just keeps going. You gotta click. So there's a lot of things you have to do. This might look intimidating, and hopefully I'm not discouraging you from taking these cases. But remember, lean on or rely on your client to do this. I would say, not especially if it's a low bono, but if you're giving your time, so they can also participate. They know who this person is far better than you do, at least they should. So they should know these things. You're probably not going to hire a private investigator. You don't have to do every one of these things. It's substantial efforts. File the affidavit. So those are the 3 pages of the motion for alternate service. So if you were getting creative and you were doing all these various things to try to locate this person, to include contacting others in their network of friends and family, even if it's via Snapchat, you're doing everything you can, and it's up to them to speak up. But you should tell these people without giving up too much information. I just need to hear from them. It's about this, something big.
Question.
Yep.
Can you address any differences when you're trying to fill out that form and having attempted all those things between someone in Maryland and someone in a different country, especially a faraway country, and what the court expects?
Can you repeat the question too, because she's sitting a little far away from the speaker.
Thanks.
So the question was, is there a difference? If so, what is it when you're trying to serve someone in a different country? And a different state is probably, that wasn't your question, but because it would be the same, right, for a different state. It is also mostly the same for a different country. There are language barriers, so that is an issue. You probably, depending on the education level and where they are, probably would want to make these contacts in their native language. Otherwise, the person doesn't know what is on the paper. But a lot of these would still apply, not all. Obviously, phone numbers and internet searches. I don't know if other countries have the same type of judiciary databases, but there are other databases. You definitely use the technique of contacting their friends and family the same way, which might be problematic for them depending on their culture. So you want to be careful with that. But you could also publish in their local papers, which is where we're going to get to at the end, because that's one of the ways that you effect service. One of the ways you effect alternate service. But that's why I wanted to start this talk by reminding people of the connection between service and alternate service. Because you're going to do all the same first you try to serve before you try to serve via alternate methods. So again, lean or rely on your client because maybe they know their husband's mother or their husband's sister, and I don't know if the economics are such that they have an email address, but even people who are of limited means usually have a cell phone, which usually has an email attached to it. And you could, I'm not scared to text, if necessary, because I don't really expect them to respond. but I screenshot it, it becomes an exhibit. I also tried to text this person. We're just trying to convince the judge on this motion here that you've done everything you can. But thank you, and that I was anticipating that, so because it is important. Rural areas, we can come up with all sorts of creative things. I'm sorry, I wasn't speaking in complete sentences. If this person lives in another country in a rural area, doesn't have cell service, doesn't have internet access, well, if money is also limited and you can't literally fly one of those Ocean City planes by with something driving behind it, then that's going to be tough. You would probably have to rely on an old-fashioned letter writing campaign or something delivered via DHL and hope that it gets there. You could be a little creative with offering at least the promise of something for a response, but let's not. You don't want to break any rules there. So as far as it goes with international service, that's what I would say. And then comes your order. So the order for alternate service, they're going to tell you how to do it. So that's the box at the bottom. How. So first, you can have it posted on the courthouse door or the bulletin board. Again, a couple hundred years too late. Have you ever read one of those things? I've only done it a couple times just because I wanted to say I did, and I have no, There's also putting in a publication. Again, probably about 30 to 50 years too late. When's the last time you saw someone sitting down in a park with a newspaper, looking through everything? But that is one of the ways that the court will probably ask you to do that, and there's a fee for that, which is difficult when you're working with pro bono and no bono cases. But Margaret will tell you that PBRC almost definitely will refund your money if you send it to them, not to ambulance. Mm-hmm. So at the bottom, sometimes the court can order you to do it by a different means. It might, but if you've done everything you can think of, I doubt that. So here's a notice. Again, these are obviously standard forms you can find online. And you obviously have to comply because you have a court order and they're not going to go forward without it. So courthouse bulletin board, these are just stock photos, obviously. We have had to publish in foreign newspapers, so we could do it on the front end and then republish in order to get the motion for alternate service. But the one, the Noticia one, Edward Leonel Serrato, that's us. And looks like someone else had the same situation going on. But these are different places of different periodicals, and this looks like it's not exactly a mainstream periodical, but it was for Honduras, where this happened. And there's a zoom in of the case, the caso numero, right there, the Howard County case for adoption. And there's also the African American. I point that out so there's a daily record. The Afro American, they charge much less, and they're more inclined to do so for MBLS cases. And the court doesn't really tell you which one to do, but the daily record and the Afro American, at least for Baltimore City, Baltimore County, are standard. And when in doubt, just call the clerk's office and ask. And then there's this. So don't forget that this order for default, you do not have an order for default. You have an order for alternate service. You have to do the service. Then you're back at square one or square two, where you basically have to file the affidavit of service and a request for order of default. Then there's your non-military affidavit again. So if you do it all up front, it's easy to do at the end because you're just doing it again. So they once again, let's say you get this, okay, granted your motion for alternate service, post on the courthouse door, okay. Then you have to pay the sheriff to do it, and then they do it, but they don't tell you they do it. You have to keep following up, so make sure you follow up with them. They might tell you, and then they have 30 days to answer again. So just wait, put it in your calendar management system. It'll pop up sooner than you think. So now you ask request for order of default and explain what you've done, that you've complied with the order, and provide a proposed order of default. But you're not done yet, right? So the court should schedule a hearing, but they might not. And different courts do it differently. I worked in Baltimore City Circuit Court for a while, and they used to not do it, and you'd have to follow up. I think they've solved that. The rule says the defendant has 30 days to ask the court to vacate the order of default. So they have another 30 days. You can ask the court to schedule a hearing for 35 days, 32 days, 40 days out, and then, because it's very likely this person is not going to file an answer, or they're not going to seek to vacate. But please put in your calendaring system to follow up with the courthouse and file a line asking for this is the end of the PowerPoint, but asking to set in a hearing, a line to request for hearing. Mention the order of default, mention you want it set out for more than 30 days, put the date in there so that an overzealous scheduling clerk doesn't do it incorrectly. You don't want to show up 28 days after the order of default and get it rescheduled. So this is usually the Q&A portion. I know we've done some Q's and A's, but here's some fun MBLS slides.
Yeah, I'll run through those if you want. So yeah, what I'm gonna do is kind of give a couple closing remarks regarding MBLS in our cases. But while I'm doing that, if folks in the audience want to think about whether they have any other questions and type those into the question box, we'll be happy to take questions in just a minute. So thank you again to Thomas. I thought this was an incredibly helpful training, and I know that this is a question we have come up from a lot of volunteers, and certainly various issues you touched on apply to a lot of our clients. So thank you so much for coming and doing this. One of the things that you mentioned was the litigation fund. So just in case anyone else is not familiar with it, generally we encourage volunteers to get any costs that you could get waived in your case waived. So for instance, filing fees, hopefully there's a standard fee waiver, and you can reach out to us if you have questions about that. But there is.
Margaret, can I say that that standard fee waiver is now only 1 page long. Maybe a lot of the people listening have practiced for a little while, but it used to be a pain in the butt. You have to list all your expenses. It's just 1 page, fill in the blank, so it's very easy to do.
So the standard fee waiver has gotten easier, yay. But there is what Thomas referenced, this litigation fund that is available for costs for cases that have that are not covered, that the volunteer attorney might be incurring. I believe that they ask that the attorney try to get pro bono or low bono service if possible, but if that's not possible in your case, you may be able to apply to that fund and get the cost of the service covered.
And let me speak on that, because recruiting good volunteers is always something that we all want to do. And PBRC does pay those fees as long as there's money in the litigation fund. It's pretty easy to do. You got to keep your receipts. You can even ask for mileage, and as long as it makes sense, if you say it's this amount of time between Frederick and Towson, for example, I'm sorry, this many miles, they'll agree with you, they'll pay it. But yes, things like perhaps the sheriff's service or the posting on the hosting fee might be waived, and you should absolutely try it, but sometimes it's quicker to just pay it and move on.
Okay, yes, I guess that's a decision you have to make. But just to remind everyone as well, some of our other resources that we have available, MBLS does provide malpractice insurance to our volunteers. We will provide mentors if you have questions and need a mentor in your case. We do have our pro bono portal, which you might have seen really briefly if you go to MBLS's website, which is up on this slide, and you click on pro bono portal, you will see this is what the portal looks like, and this is probably the easiest way to take a pro bono case from us. You can see what's available up there and go through and figure out what case you might want to take. So I'd encourage everyone who's on the webinar to visit our portal if you have not done that before. And then I just wanted to highlight that this training will be available on our website. All of our past Third Thursday webinars, as well as our other trainings that we do, are available on the website. Some of the trainings have a case requirement, but the Third Thursday webinars do not. You can just go ahead and view those. And we have a couple of upcoming trainings which people might be interested in. On December 5th, we're having a training on human trafficking and LGBTQIA populations. And then we're having another training through our tax controversy program on Airbnb, know before you rent, and taxes. So we have a lot of exciting webinars and trainings coming up, and on a variety of different topics. So please check out our website for more information about those.
I have a question.
Yes.
Who creates the headlines on the pro bono portal? Single mom can't afford a large payment, looking for a fresh start with someone in this room?
I'll make some of them. Sometimes it's another intake paralegal.
The paralegals do. Yes, yeah.
Yeah, intake paralegals make all those headlines and descriptions.
I'm glad that you enjoy it. Engaging. Yeah.
I've probably taken a couple of cases just because I've scrolled down to read more.
That's great. Good to know.
Yeah.
It looks like we do have a question from the audience, so I'm going to just take a look at what it is here. Trying to get mileage through the fund. I just want to make sure that you're talking about the litigation fund and not Judicare, because in fact we cannot cover mileage under the MBLS Judicare program. But the contact for the litigation fund, I think should be on their website, but I believe it's someone named Annie Speedy would be the person.
Yes, and they started a new form this year that's available online for the application process.
Mm-hmm.
So you can find it online and just apply there through their form, and that is how they accept requests.
And are we talking about the pro bono
The
resource
Pro Bono
center?
Resource Center Litigation Fund.
So not MBLS? Because that's
Yes,
somehow-
Pro Bono Resource Center website is where that form would be that Sarah's mentioning. So
There's also a link to it in attorney resources on our website if you want to go
Okay.
there.
Yeah.
So multiple ways to get there.
and if for some reason you still cannot find it after that, then I'm sure if you want to reach back out to the paralegal that you got your case through, or to me or Sarah, we'd be happy to make sure that you have that information.
Yes, we all have it, so it's available.
Who does it go to? It goes to the Pro Bono Resource Center, and it's an online submission, so it goes directly to them. And I don't know exactly what their timeline is. You said it's been over 30 days. I'm not sure off the top of my head what they would say is their timeline for the turnaround on that. So I can't necessarily answer that question. Okay, so seeing no other questions, I just want to again thank our presenter very much. I think we're at the end of our hour together. So thank you, Thomas. Thank you, attendees, for joining us, and we look forward to seeing you at a future training. I'm just going to go ahead and end the webinar.